Hello, my name's David Winch. I'm a forensic accountant with Bartfield's Forensic Accountants. And in this 30-minute webinar, we're going to be looking at a confiscation issue, which is generally thought to be pretty straightforward. And that is the reduction of available amount under Section 23. Sometimes the difficulty is that what you think you know, you don't check, and then actually you can make a mistake without realizing it. So we'll have a look at how Section 23 operates. What's the agenda? I'll talk about a typical situation in which Section 23 applies. And then we shall go into the detailed requirements of Section 23 and what Section 23 is not. Because it's sometimes useful to realize and to be able to explain to the defendant what Section 23 is not. Then we'll talk about the impact on default sentence, interest and time to pay, appeals, and I put appeals brackets not because actually there are no appeals, but I'll explain that. And finally, we will round up with how Bartfield's Forensic Accountants can help you. So let's look at a typical situation. As an accountant, I often find it easier to grasp ideas and to explain things by going through, if you like, a worked example with some figures. It just makes it more comprehensible to me and hopefully also to you. So let's consider John, hypothetical John. John was made subject to a confiscation order on the 20th of January last year, 2020. So a little more than 12 months ago. And the confiscation order provides that he has a benefit of £500,000, an available amount of £90,000, and no surprise here, the amount to pay is £90,000, the same as the available amount. So that's a pretty standard confiscation order situation. He's got a default sentence set in the confiscation order. It's set at 18 months. Let's look at what his available amount of £90,000 comprises. Well, it's made up of a bank balance of £10,000. Aren't we lucky that all these figures are nice round numbers? And equity in his home of £80,000. So that makes the £90,000 available amount, which the confiscation order was based around. And the due dates for payment, the court has set the 20th of February as the due date for the first £10,000. That's giving him 1 month to get that money from his bank account into court. And as far as the sale of the house is concerned, the £80,000 is required 3 months after the confiscation order was made. So that's on the 20th of April, 2020. And as you'll recognize, 3 months from the date of the confiscation order is the maximum that the court can allow initially as time to pay. Let's see what happens to hypothetical John. Well, the first £10,000 is paid on time. Not surprisingly, he's got the money in the bank. He gets it out and pays the confiscation order off by the 20th of February, that first £10,000. In practice, there might be a restraint order and there might be a bit of shenanigans to get that money paid over. But the court allowed him a month. That should be plenty of time. But an application is made and granted for an extension of time for the remaining £80,000 because he's going to have to sell his home to realise that money. And so he's asked for and been granted a further 3-month extension. You remember the confiscation order was made on the 20th of January 2020. So the extension, the maximum extension he's allowed is to the 20th of July 2020. And of course, as you will know, the court cannot grant a further extension beyond 6 months after the date on which the confiscation order was made. So this 20th of July 2020 is the final date for payment for the £80,000 that remains. Unfortunately, but perhaps not surprisingly, the property didn't sell in time, and no further payment was made by the 20th of July 2020. So interest commenced to accrue from the 21st of July on the unpaid £80,000. Again, all this is familiar territory. The sale of the home was actually completed in March of 2021. But it actually didn't sell for as much as was expected. And after payment of the mortgage, including mortgage arrears, the estate agent's fees, additional advertising costs because the house took a while to sell, legal fees and so on, there's actually only £20,000 left to pay off the confiscation order. And John has no other available amount. We mentioned interest. Interest now of £4,000 has accrued from the 21st of July 2020 up to March 2021 on the unpaid £80,000. So what's going to happen here? Well, of course, John is going to make a Section 23 application to reduce the available amount in the confiscation order. And don't forget that a Section 23 application can only reduce the available amount. It cannot increase the available amount. Even though it is now the case that the prosecution also are entitled to make a Section 23 application. In the vast majority of cases, it will be the defendant that makes the application, but the prosecutor isn't permitted now to make a Section 23 application, and might do that, for example, in circumstances where there's an amount left which is never going to be collected and he just wants to clear it off the books. So what does Section 23 require? Well, the application has been made and it requires the court to prepare a new computation of the defendant's available amount now. So if we assume this is coming into court in March 2021, what the court is going to do, required to do under Section 2, is to calculate John's available amount now, today. And John's available amount now is the £20,000 from the sale of the house, and that's it. He has nothing else. Of course, the £10,000 bank balance, which John had in January 2020, has already been paid over, and so that's not part of the of John's available amount now. So John's available amount now, £20,000, straightforward. The court then identifies the amount remaining to be paid under the confiscation order, and that's a requirement of subsection 3. And in John's case, the amount remaining to be paid is £84,000, which comprises the £80,000 which was due on the 20th of July, plus the accrued interest of £4,000. Again, you'll remember from Section 12 that interest accrued becomes a part of the amount due under the order. So the amount remaining to be paid is £84,000. And so the court has to now determine whether John's current available amount, which is £20,000, is inadequate to pay the amount remaining to be paid, which is £84,000. Doesn't take a mathematical genius to work that out. Clearly, John's current available amount is inadequate to pay the amount remaining to be paid. And that means that under Section 23, the position is that the court may, does not have to, but it may vary the confiscation order by substituting a smaller amount as the amount required to be paid under the order. As I said, it can't substitute a larger amount under Section 23. It could leave the order as it stands, or it can substitute a smaller amount. And Section 23 doesn't say what that smaller amount has to be. The court has discretion to do what is just. John, of course, is going to invite the court to substitute £30,000 of which £10,000 has already been paid as the amount required to be paid under the order. You remember originally the order said £90,000. John will invite the court to strike that out and put £30,000 in there. £10,000 has already been paid. If the court agrees, John will then be able to satisfy the confiscation order by paying the £20,000 which he has from the sale of his home. And that's it, job done. But there are some little twists and peculiarities in there which we've kind of glossed over. Let's first of all talk about what Section 23 is not. Section 23 is not an opportunity for the defendant to re-argue and relitigate matters which were decided by the court in arriving at the figures in the confiscation order. For example, it cannot reconsider what the defendant's share is in the equity of a particular property. And there's some case law on that. It is, of course, very tempting for the defendant to see Section 23 as an opportunity to go back to court and say that the confiscation order that was made should not have been made, it's not fair, it's not just, it should never have happened, he wasn't properly represented, he didn't understand the process, and in any case, he wasn't guilty of the offence. All that sort of stuff, defendants might be wanting to put up in a Section 23 application. It's not going to happen. The court is not going to want to hear any of that. The conviction is the conviction. The original confiscation order is the confiscation order. We're not talking about what his benefit was. That was fixed, and that isn't amenable to an adjustment under Section 23. What we're really looking at is what has happened since the confiscation order was made, which has meant that his available amount now is not adequate to pay the confiscation order. So in hypothetical John's case, we're saying that the property sold for less than was expected, less than its valuation at the time the confiscation order was made, that there were perhaps additional expenses of sale in terms of advertising and so on and so on. There might have been additional mortgage arrears, all sorts of things have happened since the confiscation order was made, which have changed the situation. And the Section 23 application can recognise and deal with those subsequent events. A Section 23 application is also not an application to have the court reconsider the defendant's available amount at the time the confiscation order was made. It's sometimes thought that what we're trying to do with the Section 23 is to tell the court that they got the available amount wrong when the confiscation order was made. And that's not what we're trying to do. What we're trying to do is to say to the court, if you look at the situation now, today, we're not able to pay the remaining balance on the original confiscation order. And therefore, because of events that have happened since the confiscation order was made, we need an adjustment. And Section 23 is not an application to have the court reconsider the value only of specified assets. So if the defendant had, let's say, a car and a house, and you say, actually, the car engine's failed, or gearbox has failed, or whatever, it's not worth what it was, it's scrap, let's look again at the value of the car and reduce the available amount for that. No, you've also got to look at the value of the house, which might have gone up. You've got to look at the whole available amount. And you've got to be able to explain to the court what has happened since the confiscation order to the available amount that was found when the confiscation order was made. Of course, the problem you have here is that you might have what are sometimes called hidden assets. you might have had the court come up with a figure of available amount which was not based on identified assets. And you cannot, in a Section 23, go back and say those hidden assets, they never existed in the first place, they don't exist, we should ignore them and bring the available amount down. That's not something that's acceptable in a Section 23 application. So if you've got hidden assets, if you've got tainted gifts, you cannot just wipe them away and pretend that the court had never found them when you're doing a Section 23. So what you've got to do, as I say, is to look again at the defendant's current available amount in full. What about the default sentence? Well, you might think if the available amount is changed and the amount ordered to be paid is changed, surely the court should look again at the default sentence. Let's think about hypothetical John. His available amount was said to be £90,000. His default sentence was set at 18 months, which is perfectly sensible for a £90,000 order. But now we find that his available amount is going to be £30,000. The amount he's ordered to pay is £30,000. Shouldn't we look again at that default sentence and reduce it to something like 6 months or 9 months? Well, Section 39 applies to the default sentence when an order is varied under Section 23, and this section is quite restrictive. In most cases, no amendment can be made to the default sentence, and that's in particular because of Section 39(1)(b). What that does is to say that the court may vary the default sentence if, and only if, the effect of the variation of the order is to vary the maximum period applicable in relation to the order under Section 35(2)(a). And as you know, under 35(2)(a), we've got 4 bands. We've got quite wide bands for default sentences. There's kind of 0 to £10,000, 10,000 to 500,000, 500,000 to £1 million, and over £1 million. Those are the bands under subsection 2A of Section 35. And in order to have an opportunity to vary the default sentence on a Section 23 application, we have to have moved to a lower band. Now, hypothetical John, his order for 30,000 is in the same band as a £90,000 order, because as I've said, that band goes from 10,000 to 500,000. So it's not possible for the court, it's not open to the court to vary the default sentence in the original confiscation order. So it stays at 18 months. So just be aware of that, the court doesn't have free rein to reconsider the default sentence when there's a Section 23 application. What about interest? Well, actually, the statute contains no express provision dealing with interest on a confiscation order, which is varied under Section 23. The statute actually provides that interest must be charged from the due date for payment, and we shall come on to the due date for payment in a moment. In practice, what happens is that interest which is accrued prior to the making of the variation is simply evaporates. Everybody ignores it as if it never existed. So that £4,000 of interest that had been added to hypothetical John's order, we'll just forget it. It appears that the courts in practice operate as if interest commences afresh, as if the confiscation order had been made on the date that it was varied. Now, as I say, that's not statutory, but that seems to be, in practice, what the courts do. I mentioned time to pay. Well, similarly, the statute contains nothing, no express provision dealing with time to pay on a confiscation order which has been varied under Section 23. There's all this stuff about time to pay when a confiscation order is made, and as we know, it's the default position, if you like, is that the confiscation order is due on the date it's made. But the court can allow time to pay, and it can initially allow 3 months, and then it can allow a maximum of a further 3 months. So a maximum of 6 months after the date the confiscation order is made. But time to pay when a confiscation order is varied, nothing in the statute about that. Again, in practice, it appears that the court allows time to pay as if the confiscation order had been made on the date it was varied. On a strict reading of the statute, however, the time to pay cannot exceed 6 months after the date the confiscation order was made. And that date's probably well gone, hasn't it, by the time we look at a variation. In John's case, the confiscation order was made on the 20th of January 2020. The 6 months expired on the 20th of July 2020, and we're doing a variation in March 2021. So 6 months has already come and gone. But it seems as if the court feels that it's got powers to allow time to pay as if the court was making the order rather than varying it. I suppose it might be sensible if the defendant is not facing imminent proceedings in the magistrates to commit him to prison, to delay making the Section 23 application until, in John's case, the house is sold, the money is in the bank, and we know that we're going to be able to pay it promptly. Because what we don't want to do is to have a reduction made and then not be able to pay the reduced amount. There is, in fact, nothing to stop you going back and making a further Section 23 application if circumstances change. So if you think that house is going to sell for sufficient to give 20,000, and then in the event it sells for even less and he's only got 15,000, well, you can go back and make a further Section 23 application, but I would imagine you wouldn't really want to. Appeals, as I say, appeals brackets not. It does appear that neither the defendant nor the prosecutor can appeal a decision on a Section 23 variation application. The defendant cannot appeal because a Section 23 variation is not a sentence under the Criminal Appeal Act. And there is case law on that. The case is on the slide where somebody did try to appeal a Section 23 variation, and the Court of Appeal said, no, we don't have jurisdiction to hear an appeal on the Section 23 variation because it's not a sentence. And my personal view, and I'm not a lawyer, I'm an accountant, but my personal view is that the prosecutor cannot appeal because a Section 23 variation does not involve the making or the not making of a confiscation order. As you know, under Section 31, the prosecutor can appeal where a confiscation order is made, and can appeal where the court decides not to make a confiscation order. But in my view, under Section 23, the court is not either making or not making a confiscation order. The confiscation order, hypothetical John's case, was made in January last year. What the court is considering doing is varying or not varying a confiscation order. So it seems to me, my own reading of Section 31 is that the prosecution cannot appeal a Section 23 outcome. However, there's nothing to prevent either the defendant or the prosecutor subsequently making a fresh Section 23 application when circumstances change. I suppose you'd be hoping that you wouldn't come in front of the same judge if he's turned you down the first time and you've got a minor change and you try it again, you might get turned down again. So what this does seem to do is, if you have a situation where, from a defendant's point of view, you've had a delay in getting the money, you've had a delay in getting payment made on a confiscation order, and interest has racked up, then if you can get a Section 23 application in, the effect of it, rightly or wrongly, may well be that the interest which is racked up to date just evaporates and is forgotten about, and the clock is set back to 0 and we start again. So there might be advantages from a defendant's point of view in making a Section 23 application, even if you've only got a very modest shortfall, just in order to get that interest swept away. Okay, so that's Section 23 applications. How can we help? Well, frankly, in terms of forensic accountancy, we do not often get called in on a Section 23 application, because usually by that stage, if you like, the house has been sold, the money's waiting to be paid, there aren't any forensic accountancy issues to deal with. But of course, in confiscations generally, and in criminal cases generally, pre-trial, and indeed in civil cases, Bartfield's forensic accountants, we are fully staffed. We are undertaking legal aid work, privately funded work, criminal and civil forensic accountancy work. It is relatively easy for us to conduct the bulk of our work remotely using our up-to-date and secure IT facilities. And we remain readily contactable by phone, by email, and online through video links. Only the other day, I was, as it were, in prison on video, talking to a solicitor and a prisoner about his confiscation. Our recently updated website is full of useful information, and of course, that's accessible 24/7. You can find more on this topic and other topics in our news section, where we have blog articles, and the webinar recordings are in the seminars section of the website, so you can access a copy of the recording. In any event, a free recording of this webinar will be emailed to you. And if you want to get in touch with me, my email address is there on the slide, and the phone number. It is much preferable to get hold of me by email, because anything slightly complicated isn't easily dealt with on the phone. Much better to get some facts down and some documents to me by email. I can have a proper look and get back to you with a considered opinion. Okay, there we are. We shall be back in a fortnight with another webinar, and I look forward to seeing you then. Thank you, and bye for now.